Hey, welcome back to Liberal Dan Radio here on YouTube. This is Liberal Dan Radio, talk from the left, that's right, and we are bringing some final thoughts before closing in the Kyle Rittenhouse trial. Now, I'm not a lawyer, and I didn't stay at a Holiday Inn Express last night, but I am going to try and give a layperson's explanation of what should be going on tomorrow and what I expect from jury deliberations before hearing closing arguments. Tomorrow, you are going to be seeing the judge give instructions to the jury, including his final decisions on what lesser included charges will be allowed. You will then see both sides give their closing arguments, and the prosecution will get a chance to give a rebuttal after the defense closes. Now, first and foremost, let's get some things that aren't true out of the way. Kyle never took the gun across state lines. That is one of the factually incorrect statements that I hear the most. However, that's not the only incorrect or irrelevant statement that I've heard recently about this case. Many who believe Rittenhouse to be factually innocent will bring up the criminal past of the people Kyle Rittenhouse shot. However, unless he knew about their criminal histories at the time of the shootings, those facts are irrelevant to the determination if deadly force was reasonably used or not. Some have argued that Ziminski firing his gun may have caused Rittenhouse to be reasonable in using deadly force against Rosenbaum because he wouldn't know that it wasn't Rosenbaum that had the gun. But Rittenhouse testified on the stand that he knew that it wasn't Rosenbaum who fired the gun, so that's another irrelevancy that some have introduced. Some have also introduced other legal theories about the firing of the Ziminski gun and Kyle's reasonableness of his behavior thereof. I'm not going to cover those here as they are not negated by Rittenhouse's own testimony. Now, let's talk about the charges that are faced by Kyle Rittenhouse. I've had some discussions over if the weapons charge should have effect on if Kyle acted reasonably in using deadly force or not, because he is charged with carrying a deadly weapon that he would be not legally capable to carry. It doesn't seem like the prosecution is going to try and use his illegal carrying of a weapon in trying to convict him on the other charges pertaining to the shootings. And this is probably a smart decision, and here's why. The gun charge may very well be the one that Rittenhouse is most likely to get convicted of. The law that creates exceptions for people under 18 to carry a rifle seems to have been written only to be an exception for hunting. However, the law is very poorly written. So if he's convicted of the weapons charge, it could very well be overturned on appeal simply because of the fact that it was poorly written. And if the prosecution ties the other charges pertaining to the shootings with the use of an illegal firearm, then overturning the weapons charge on appeal could then trigger the entire house of cards to fall down if the prosecution is able to get those other convictions as well. Now, the judge does seem inclined to allow the jury to hear about the exceptions in the law and how they are worded. So both sides can argue the vagaries to the jury, and the jury will be able to decide. But if the law is as the defense claims it is written, Rittenhouse would be allowed to walk around openly carrying an AR-15, but not nunchucks. Does that make sense? It doesn't to me. But sometimes laws are poorly written. And if the law is so poorly written that you can't discern the meaning of it, and as such you can't determine if Rittenhouse violated it, at that point you would need to acquit. Now on to the charges pertaining to the use of the rifle. Kyle Rittenhouse killed Joseph Rosenbaum. The prosecution is trying to prove, beyond reasonable doubt, that the killing was a reckless homicide. The defense has claimed self-defense, so that means the prosecution must show that those actions were not reasonable in defending his own life. A reasonable person would have to believe that their own life was in danger in order to justify the use of deadly force against Rosenbaum. There has been testimony that Rosenbaum made threats against the group Rittenhouse was with and individually against Rittenhouse specifically before the chase happens. Rosenbaum at one point does give chase to Rittenhouse, and seconds later, Rosenbaum was shot 4 times. If the prosecution was smart, something that I have questioned over the duration of this trial. What will they have to do to lay out the case to the jury? Well, here's what I would do if I was an attorney, but I'm not an attorney, but here's what I would try and do tomorrow. First of all, they're going to try and claim that the first shot was unreasonable, that Kyle Rittenhouse's life was not in danger, and not in a danger that would reasonably allow for the use of deadly force. You, as a viewer, might disagree with that, but that's what the prosecution, I feel, will likely argue if they're going to make an effective argument. But what they would then say is this. Let's say you do believe that the first shot was reasonable. That first shot, according to one of the experts who testified, shot him in the hip and caused him to fall. So, is now the man who had his hip shot a threat to continue to chase after Rittenhouse? If not, would the second shot be reasonable? What about the third? What about the fourth? All the prosecution would have to do is to show that any shot up until the shot that mortally wounded Rosenbaum was not reasonably taken in self-defense, for the self-defense charge to be negated. Of course, on the stand, Rittenhouse answered the question as he should, which is that he kept shooting until Rosenbaum was no longer a threat. And the defense will likely argue that the timing between shots wouldn't have allowed Rittenhouse to stop firing to determine if he was a threat or not. So the jury will have to determine if the timing is relevant or not. Was firing 4 shots so quickly close together reasonable in self-defense when one shot could have sufficed to stop Rosenbaum? Reporter Richie McGinnis also testified that Rosenbaum lunged for the gun. Was Rosenbaum justified in lunging for the gun in his own self-defense? Was the lunge for the gun enough to trigger self-defense? The jury will have to figure that one out. But there is also another issue to consider. Did Rittenhouse provoke people around him by aiming his gun at people like Yellow Pants Guy or the Zelinskys or Rosenbaum? The judge seems to be inclined to allow this instruction, to allow the jury to make up their own minds on if Rittenhouse provoked people or not. If the jury is convinced by the prosecution that Rittenhouse provoked those around him, this would then give Rosenbaum the right to go after the gun in self-defense. Also, when you are provoked, under Wisconsin law, you are not afforded the same rights to self-defense as if you were not provoking the attack. When someone provokes an attack, the provocateur is required to give adequate notice that they are disengaging from the fight in order to regain the right to use deadly force when another reasonable person would have feared for their life. If no adequate notice is given, then they must exhaust every other option available to them before using deadly force. Some have argued he ran, so that means he ran away, and that is adequate notice. Looking at some of the footage, Rittenhouse does run for a few seconds, but then turns to aim. Will a jury determine that this is adequate notice of disengagement if Rittenhouse was the provocateur? That is unclear to me at this time. Another charge pertaining to the Rosenbaum shooting is that he recklessly endangered the safety of others using a deadly weapon. McGinnis said that he was in the line of fire when Rosenbaum was shot. I feel that this charge is likely to be coupled with the Rosenbaum verdict, i.e., if shooting Rosenbaum was reasonable, then how could it be reckless towards McGinnis? But if the shooting of Rosenbaum wasn't reasonable, then that makes it more likely that Rittenhouse recklessly endangered the safety of others, specifically McGinnis. The next charge is another reckless endangerment charge pertaining to the shots fired at the one who people call Jump Kick Guy. This charge is clear. Did the unknown person jumping and kicking Rittenhouse justify the firing of both rounds or not? If the jury believes Rittenhouse to have provoked, did he then give adequate notice of removing himself from the fight or exhaust every other possible other means to defend himself before resorting to deadly force? So that's pretty much, probably won't be a very long argument. The prosecution will likely say, do you believe that deadly force was reasonable in this case? Was it self-defense? And if it was self-defense, was deadly force reasonable in self-defense? If no, then they would have to convict. The next count comes when Rittenhouse shot Anthony Huber, who twice struck Rittenhouse in the head with a skateboard. The charge here is the most serious one. intentional first-degree homicide, which is why the prosecution asked if Rittenhouse had intended to point the gun at Huber and kill him. And that's all that is generally needed to convict someone of intentional first-degree homicide, unless the prosecution can't disprove the self-defense claim. Self-defense would allow you to intentionally shoot and kill somebody. Rittenhouse claimed that he didn't intend to kill while on the stand. However, pointing a rifle at someone and pulling the trigger means you intend to shoot the person. Not sure if there's much difference under the law between intending to shoot and intending to kill, especially as using a gun to shoot somebody is, by definition, using deadly force. The shooting against Huber may very well have lesser charges included. Second-degree intentional homicide, which would allow Rittenhouse to believe his life was in danger and that it was necessary to use deadly force, but the jury would then have to find either of those beliefs to be unreasonable to convict. The other lesser included charge that could be allowed for Huber's shooting is first-degree reckless homicide, which would only require the prosecution to believe that Rittenhouse killed Huber with utter disregard for human life. And again, the ability to claim self-defense here will be made harder if the prosecution is able to claim and prove to the jury that Rittenhouse provoked. The last count Rittenhouse faces is the charges for shooting Gage Grosskreutz, attempted first-degree intentional homicide using a dangerous weapon. The prosecution has made a point that Grosskreutz raised his arms, and Grosskreutz felt that his raising his arms was showing that he didn't want to fight further. The defense has said that after the hands were raised, that how Grosskreutz was holding his gun would have allowed Rittenhouse to believe that he was about to be shot, and thus justify the use of deadly force. And again, if provocation is proved, that would again limit the ability for Rittenhouse to claim self-defense. Another charge that had been brought against Rittenhouse was the one of violating curfew, but that was dismissed earlier in the case. I'd always felt that this charge was stupid, and that any defense attorney worth their salt would have been able to get it tossed out because the police pretty much allowed anybody to be there that night. So how could you punish one and not the rest? But what do I believe will happen? Clearly, I do think that there will be a guilty verdict on the weapons charge. He would likely get time served for that guilty verdict if he gets it. But I also think that it's likely to be appealed and that it will likely to be overturned because of how poorly the law is written. I believe that a guilty verdict on shooting Rosenbaum will probably open up the door for guilty verdicts in all the other charges. However, unless the prosecution is able to tie up their case in a pretty little bow, I find it unlikely that he gets convicted for Rosenbaum's death. Not because I think his actions were reasonable, but because of how difficult it is to prove that his actions were not reasonable beyond reasonable doubt. And as I said, not guilty on shooting Rosenbaum probably also means not guilty on the reckless charge pertaining to McGinnis. I believe that Grosskreutz holding the gun in the way that he did may put enough doubt in the jury's mind to not allow a guilty verdict here as well. Do I believe that Rosenbaum shooting Grosskreutz was reasonable? No. Do I believe that the jury will be able to get rid of enough doubt to convict? No. Will the jury believe that the one kick to the head justifies shooting 2 rounds that hit nobody? Will the jury believe that 2 skateboard hits justifies a shot in the chest? To answer those questions, you have to ask yourself this question. Is Binger doing a competent enough of a job with this case? Do you believe that Binger can successfully make that argument to the jury? I think that if an attorney who had made no mistakes, that didn't take 10 minutes to explain something that only needs 2, and that didn't require the judge to kick the jury out twice before being admonished, that type of attorney would have been able to get convictions for at least jump kick guy, if not Huber. But I've seen Binger drone on for 10 minutes or more on something that could have been easily described or asked in 2. I have seen Binger make several unforced errors in how he has worded things in his arguments to the judge, and I see no reason why he then wouldn't also make mistakes in his arguments to the jury. And while the jury didn't get to see the admonishment of the prosecution because they were asked to leave the room, they still got to see the objection by the defense and the instruction to leave, And one would think that most jurors would be able to figure out that Binger done messed up. That's why that, despite my belief that Rittenhouse's use of deadly force was not reasonable, that I do not believe that they will be able to get any convictions for any of the shootings themselves. One more thing I wanted to bring up. There has been thoughts raised about what asking for lesser included charges means to the prosecution. Some believe that because the prosecution asked for them, that means that they don't have faith in the case that they've made, so they want the jury to be able to convict on lesser charges, meaning it's easier to convict on them. But remember, while the prosecution benefits by not having to prove as much for a lesser charge, the defense also benefits because a lesser included charge means less time in prison. And the defense did not object to all of the lesser included charges. So both sides are benefited by the inclusion of these lesser includeds. And while it may be more of a benefit to the prosecution, there is also a benefit to the defense as well. But I could be wrong. What do you think? Do you disagree with my assessment of the trial? Do you disagree with my assessments of Binger? Do you think we will see guilty verdicts beyond the dangerous weapons charge? Let me know in the comments, and remember to smash that like button ever so lovingly. Share this video with your friends who may be getting the facts of the case wrong, and subscribe to the channel so you can be notified of any new content. Thank you.